For decades, millions of immigrants believed that the moment they raised their right hand and took the oath of allegiance was the finish line. The paperwork was over. The interviews were over. The waiting was over. Citizenship meant permanence. It meant security. It meant that no matter what political winds blew through Washington, your status as an American could never be questioned again. But in 2026, that assumption is being quietly tested in a way we have not seen in generations. A new piece of legislation moving through Congress, combined with a dramatic shift in immigration enforcement priorities, could make it significantly easier for the government to strip naturalized citizens of their citizenship. Not people at the border, not undocumented arrivals, not visa overstays. People who already became Americans. People who built businesses, bought homes, raised children, and voted in elections believing their immigration journey was permanently behind them. The bill is called the Stop Citizenship Abuse and Misrepresentation Act, or the SCAM Act. Supporters say it simply closes loopholes and protects the integrity of citizenship. Critics warn it could open the door to something far broader, a system where citizenship for naturalized Americans feels conditional rather than permanent. And what makes this moment especially serious is not just what the bill says on paper, but the scale of enforcement already being discussed behind the scenes. Internal targets that could increase denaturalization cases from a handful each year to thousands, expanded definitions of fraud, and a 10-year window after naturalization, during which certain actions could trigger proceedings. The question is no longer whether denaturalization exists. It always has. The real question is whether it is about to become common. And if it does, who ends up caught inside that system? Hi, I'm Sophia, and on this channel we break down major US policy changes in clear, straightforward language so you can understand what's happening without the noise or political spin. If you're a naturalized citizen or you love someone who is, this conversation matters. Today, we're going to walk carefully and methodically through what the SCAM Act actually proposes, how denaturalization works under current law, why enforcement numbers are suddenly increasing, and who could realistically be affected if this bill becomes law. My goal here is not to create panic and not to dismiss concerns either. It's to separate facts from fear so you can make informed decisions based on reality, not rumors. By the end of this video, you'll understand what's at stake and what practical steps, if any, you should be considering. 1. What citizenship has traditionally meant. For generations, American citizenship has been treated as one of the most secure legal statuses in the world. The path to get there is not simple. Anyone who has gone through it knows that. You start with years as a lawful permanent resident. Then come background checks, fingerprints, interviews, English and civics tests, travel history reviews, employment and tax questions. Eventually, you stand in a federal courtroom or government building, raise your right hand, and swear allegiance to the United States. That moment is not just symbolic fluff. It represents finality. It represents acceptance. It represents the understanding that you are no longer temporary, no longer conditional, no longer in between. You are American. That promise of permanence has shaped entire lives. Naturalized citizens have built businesses, bought homes, joined the military, run for office, raised children here. They did all of this with the confidence that their legal identity in this country was stable. A U.S. passport is more than a travel document. It's proof that the uncertainty is over. Importantly, this belief hasn't just been cultural, it has been legal by design. Lawmakers understood that if naturalized citizenship could be easily revoked, it would undermine the entire purpose of naturalization. So they built guardrails. They created a system where denaturalization, the legal process of revoking someone's citizenship, was supposed to be rare, difficult, and reserved for extreme circumstances. Not administrative sloppiness, not minor errors, not misunderstandings on complex forms completed years earlier in a second language. Extreme circumstances. 2. How denaturalization works under current law. Under current federal law, the government can pursue denaturalization primarily if citizenship was illegally procured, or obtained through concealment of a material fact, or obtained through willful misrepresentation during the naturalization process. That timing matters. The alleged fraud must have occurred at the time the person applied for and obtained citizenship. Prosecutors must prove that the individual intentionally lied or deliberately hid information that would have disqualified them. And the burden of proof is high. Courts talk about clear, convincing, and unequivocal evidence. Judges repeatedly emphasize that stripping someone of citizenship is one of the most serious actions the government can take. It can't be based on suspicion, minor inconsistencies, or innocent mistakes. There is a crucial distinction between someone who knowingly falsified a material fact to gain citizenship and someone who misunderstood a complicated question, forgot a short trip from years earlier, or made a clerical error. For decades, that distinction protected millions of immigrants who navigated a complex system in good faith. That's why denaturalization cases have historically been extraordinarily rare. In a country of more than 330 million people, with roughly 26 million naturalized citizens, the average number of denaturalization cases has often been cited in the range of about a dozen or so per year. Those cases usually involved egregious fraud, war crimes, terrorism, or serious national security threats, exactly the kind of extreme misconduct the system was designed to catch. And here's a point many people misunderstand. Committing a crime after you become a citizen does not normally jeopardize your citizenship. If a naturalized citizen commits a serious crime years later, they can be prosecuted, imprisoned, fined, and punished under criminal law like anyone else. But their citizenship is not automatically revoked just because of post-naturalization conduct. The logic is simple. Once you're fully admitted into the political community as a citizen, your status is no longer supposed to be tied to ongoing behavior the way a visa or green card can be. Citizenship marks the end of that conditional relationship. Post-naturalization conduct only matters if it reveals a lie during the original application. For example, if someone hid membership in a terrorist organization when applying, and that deception is later uncovered, denaturalization can occur because the fraud happened during naturalization. Timing is everything. The law has drawn a bright line at that moment of oath. The Scam Act is aimed squarely at blurring that bright line. 3. What the Scam Act would change. The Stop Citizenship Abuse and Misrepresentation Act was introduced in early 2026 by Senator Eric Schmidt in the Senate and Representative Tom Emmer in the House, at a time when immigration enforcement was already a central priority of the administration. Supporters frame the bill as a targeted reform to close dangerous loopholes. They point to cases where people allegedly committed serious fraud, like large-scale benefits fraud, after becoming citizens. Under current law, unless the government can tie that misconduct back to lies during naturalization, citizenship generally remains intact. To them, that's a design flaw. They argue that if someone commits serious fraud or serious crimes against the United States government, the law shouldn't be powerless just because the person already took the oath. Critics, however, argue that the bill goes far beyond closing loopholes. It restructures when and why citizenship can be revoked. Here are the major changes. A. Expanded fraud grounds. Right now, the focus is on fraud during naturalization. Under the Scam Act, denaturalization could also be based on material fraud against the United States government more broadly, not just at the moment of citizenship. That can include benefits fraud, significant tax fraud, immigration petition fraud, other serious deception involving federal agencies. In other words, a naturalized citizen who commits qualifying fraud years after becoming American could face both criminal penalties and a separate civil action to revoke their citizenship. That's a fundamental shift away from the timing-based model we've had for decades. B. Aggravated felonies as a standalone trigger. U.S. immigration law has a category called aggravated felonies. These include murder, rape, sexual abuse of a minor, drug and firearms trafficking, certain large-scale fraud and money laundering offenses, some serious theft or violent crimes, depending on sentence. Under current rules, if a green card holder is convicted of an aggravated felony, they can often be deported. But if a citizen is convicted of an aggravated felony after naturalization, they face criminal penalties, prison, fines, probation, yet their citizenship remains intact. The Scam Act would change that. A conviction for an aggravated felony would become an independent ground for denaturalization. The crime wouldn't need to be tied to the naturalization process. Supporters say this ensures that people who commit the most serious crimes don't continue to enjoy the protection of U.S. citizenship. Critics say it turns citizenship into something that can be revoked based on conduct long after the oath, creating a more conditional form of membership. C. Expanded national security and organized crime grounds. The bill also broadens language around affiliation with terrorist organizations, espionage and foreign intelligence work for hostile governments, participation in transnational criminal enterprises. Some of this exists in narrower form today when tied to concealment during naturalization. The Scam Act would codify and expand these grounds more explicitly. The concern isn't necessarily the idea of targeting terrorists or major criminal figures. Most people agree on that. The worry is how broadly terms like affiliation or participation might be interpreted in practice, especially in a heated political climate. D. Evidence and standards. Denaturalization is a civil proceeding, not a criminal one. The burden of proof is high, but it is not beyond a reasonable doubt. The Scam Act includes language that, according to supporters, simply clarifies what kinds of evidence can be used, including more documentary and circumstantial evidence. Critics fear that in practice, this could lower the effective bar, making it easier to bring cases based on old files, inconsistencies, or ambiguous records instead of clear, intentional deception. When the consequence is losing citizenship, even subtle shifts in evidence rules matter. E. A 10-year post-naturalization window. Perhaps the most psychologically significant change, the introduction of a formal 10-year window. Under the bill, certain offenses, like material fraud against the government or aggravated felonies, that occur within 10 years of naturalization could be used to initiate denaturalization proceedings. Historically, the longer someone lived as a citizen without issue, the more secure their status was assumed to be. This provision reframes that understanding. For the first decade after becoming American, your conduct could potentially reopen what you thought was a closed chapter. Taken together, these changes would be the most significant expansion of denaturalization authority in modern U.S. history. If this breakdown is helping you understand what's actually in the bill, consider subscribing so you can follow what happens as it moves through Congress. Immigration law is changing fast in 2026, and clarity matters more than ever. 4. The quiet shift in enforcement. Legislation on paper is only half the story. The other half is how aggressively the government chooses to use the tools it already has. For years, denaturalization existed mostly in theory for nearly everyone. Technically possible, but practically invisible. Maybe a dozen or so cases nationwide in a typical year. In a population of about 26 million naturalized citizens, that number is microscopic. It reinforced the idea that denaturalization was reserved for war criminals, terrorists, and extreme fraud tied directly to the citizenship process. But in 2026, immigration attorneys and former officials report a shift. Field offices within U.S. Citizenship and Immigration Services, USCIS, are reportedly being encouraged to re-examine old naturalization files more proactively, flag and refer more cases to the Department of Justice. Instead of mostly reacting to clear tips or discoveries, officers are being asked to look. According to multiple legal observers, internal discussions have floated targets of 100 to 200 denaturalization referrals per month. If anything close to that holds, that could mean over 2,000 referrals a year, a massive jump from historical norms. Even without the Scam Act, that kind of scale would change the nature of denaturalization. What was once exceptional starts looking routine. When bureaucracies operate under numerical expectations, incentives shift. Officers begin searching for potential cases rather than waiting for the rare obvious one. Borderline situations receive more scrutiny. Some cases that might previously have been closed could now move forward. None of that automatically means abuse or bad faith, but it does mean more people pulled into a process that is expensive, slow, and emotionally draining, sometimes for years. Now imagine that environment plus the Scam Act's expanded grounds. More things count as fraud. More crimes trigger denaturalization. There's a formal 10-year window. Evidentiary rules are looser. The universe of potentially reviewable cases grows dramatically. 5. Who could realistically be affected? Supporters insist the answer is simple: serious criminals, national security threats, and people who never deserved citizenship in the first place. Law-abiding naturalized citizens, they say, have nothing to worry about. But critics warn the reality on the ground is rarely that clean. Terms like material fraud and affiliation are not self-defining. They require interpretation by officers, by prosecutors, and by judges. Let's look at a couple of realistic, non-sensational scenarios. Scenario 1. Benefits misreporting. Imagine someone who became a citizen 8 years ago. 3 years after naturalizing, during a period of financial hardship, they applied for a federal benefit and misreported their income. Maybe they misunderstood how to count certain earnings. Maybe a preparer made an error. The agency caught the discrepancy, required repayment, and assessed a penalty. The person paid it back and moved on. Under traditional denaturalization rules, that incident wouldn't reopen their citizenship because it wasn't tied to fraud during the naturalization process. Under the Scam Act, if officials decide that misreporting was material fraud against the United States and it occurred within the 10-year window, it could form the basis for a denaturalization case. That doesn't mean they would automatically lose citizenship, but they could find themselves defending their status in federal court, hiring lawyers, and living in uncertainty for years. Scenario 2. Serious criminal conviction. Now consider someone who became a citizen 5 years ago and was later convicted of a serious drug trafficking offense classified as an aggravated felony. Under current law, they would serve their sentence, pay fines, and carry a permanent criminal record, but they would remain a citizen. Under the Scam Act, that same conviction could be a direct trigger for denaturalization. After prison, they might face a separate civil lawsuit to revoke their citizenship and potentially be removed from the U.S. For someone who has spent decades here, whose children are U.S. citizens, and who has no real ties left in their country of origin, that's a life-altering consequence layered on top of criminal punishment. Scenario 3. Old file inconsistencies. Immigration files can stretch across decades and multiple applications: visas, green cards, work authorizations, adjustment, naturalization. Dates, addresses, jobs, and travel histories are repeated again and again. Minor discrepancies are common: a misremembered travel date from 15 years ago, a typo in a job title, a name spelled slightly differently. Under a narrow, intent-focused standard, these rarely pose a risk. But in an environment where thousands of old files are being proactively reviewed, and where evidentiary rules may be interpreted more flexibly, a small percentage of those inconsistencies could be viewed as suspicious rather than harmless. Most such reviews will probably go nowhere, but for the people who do get pulled into litigation, the impact is enormous, regardless of whether the government ultimately wins or loses. This is why critics warn of a two-tier citizenship system. One tier for people born in the US, whose citizenship is almost never questioned. Another for naturalized citizens, who may feel like their status is effectively on probation for a decade or more, depending on how the law is enforced. 6. What you can realistically do. If you're a naturalized citizen watching this, here's what's most important to understand. The Scam Act is proposed legislation. It is not law yet. It may be amended, narrowed, delayed, or blocked. Even if it passes, the vast majority of naturalized citizens who obtained citizenship honestly and live law-abiding lives are unlikely to face denaturalization. But in a shifting enforcement climate, awareness is not overreacting. It's common sense. A few practical steps. Stay informed from reliable sources. Don't rely on social media rumors or viral posts. Follow reputable news outlets, experienced immigration lawyers, and established nonprofits. Look for people who quote the actual text of bills and court decisions, not just headlines. Organize your records. Keep copies of your green card and naturalization documents, old immigration forms if you have them, tax returns, federal benefits applications, or correspondence. Most likely, you'll never need them. But if questions ever arise, having a complete personal file can make a huge difference. Get clarity on any past complexities. If your immigration history involved complicated issues, long trips abroad, prior denials, criminal charges, or confusing paperwork, consider a one-time consultation with a qualified immigration attorney. This is about peace of mind and early clarity, not panic. Take official notices seriously. If you ever receive a letter or summons from USCIS, the Department of Justice, or any federal court about your citizenship, do not ignore it. Don't try to handle a denaturalization case alone. These are high-stakes civil lawsuits. Know your basic rights. As a citizen, you have constitutional protections. You have the right to remain silent, the right to counsel, and the right to be free from unreasonable searches. Being respectful with officials is wise. So is understanding where your legal boundaries are. None of this means you should live in constant fear. The goal is the opposite: preparation so you don't have to live in fear. 7. The bigger question: what does citizenship mean now? Zooming out, the SCAM Act is part of a broader shift in how the U.S. talks about immigration enforcement. For many years, the national conversation focused mostly on the border, visas, asylum, and undocumented presence. Now, enforcement is increasingly turning inward, toward green card holders, and, more than before, toward naturalized citizens. Historically, citizenship was the end point, the moment when immigration enforcement essentially stopped for you. Denaturalization was a rare exception. In 2026, that boundary is being questioned. Even if this particular bill never becomes law, the fact that denaturalization is being discussed as a major enforcement tool is itself a significant change. At its core, the debate raises a fundamental question: what does it actually mean to become American? For more than a century, the promise of naturalization has been clear. No matter where you were born, once you met the legal requirements and took the oath, you stood on equal footing with every other citizen. The SCAM Act doesn't erase that promise overnight, but by expanding the grounds for denaturalization and increasing enforcement activity, it does test the edges of that promise. Supporters argue that accountability strengthens citizenship by protecting it from abuse. Critics argue that making citizenship more revocable for one group of Americans erodes the sense of equality and permanence that citizenship is supposed to guarantee. How Congress, courts, and agencies resolve that tension will shape the lived experience of millions of naturalized citizens in the years ahead. If you found this breakdown helpful, subscribe and turn on notifications so you don't miss Global Visa Guide updates as this legislation develops. I'll keep tracking the bill, any amendments, enforcement data, and court decisions so you can see beyond the headlines to the actual implications. Share this video with anyone who naturalized in the past decade, or anyone worried about how these changes might affect their family. Clear, accurate information is one of the most powerful tools we have in uncertain times. The meaning of American citizenship has always evolved alongside the country itself. The question now is how it will evolve in 2026 and beyond. Stay informed, stay prepared, and I'll see you in the next update.